Court of Appeal in the 4th and 5th District of the State of Florida is now in session. The Honorable Joseph Beaupre, Judge, presiding. All persons having business before this court draw near, your attention will be heard. May God save the United States of America, the State of Florida, this honorable. Please be seated.
Good morning again. Our next case on the docket is case number 24-2092, Muhammad versus NREA SE1 Andros. Is the appellant ready to proceed?
Yes, sir.
All right. Come on forward.
Usually appellants sit over there for some reason, but now we had to switch. There you go. How about that?
And please let us know when you come forward how much time you'd like for rebuttal. Okay, sir?
May it please the court. Darren Elkine on behalf of the appellant, I'd like to reserve 5 minutes for rebuttal. This was a case in which the defendants agreed with the plaintiff there was a defect on the property that the that the defendant, Andros Isles, and I'm going to refer to it, Your Honors, as the property owner and the property manager. Those are the two defendants, although they were represented by the same counsel. All defendants agreed that there was a defect on the property owned by the defendant, property owner. This was an apartment complex, a rental apartment complex that had a pool facility, clubhouse, and 2 masonry grill enclosures, and they agreed that the grill enclosures, everyone agreed, that the grill enclosures were defective because they lacked adequate or lacked any ventilation in the grill enclosures. These were defects which were not visible to the untrained eye. And it's important that the grills had actually been replaced twice prior to the incident where the appellant was injured. The testimony is that these grills, the 2 replacements of the grills prior to the plaintiff's injury, were procured by the management company contacting a company called HD Supply. And the record testimony from the trial was that HD Supply was a turnkey vendor. That's their term.
Who brought in that testimony? Did your client bring that testimony in, or did the property manager of the apartment complex bring that in?
Actually, a representative of the property owner and the property manager brought that testimony in, and I can read that testimony to the court if it's helpful. But that testimony came from both the owner and the manager, and the property owner described what HD Supply is. It's a company that's well known.
Did that come out when your client was questioning them, or did that come out in their case?
That came out when, and I was the trial attorney, when I was questioning, my client was questioning.
Again, you brought out that testimony, is that
correct?
Yes,
from
your
Your
questioning. That was, I'm sorry. Yeah.
Yes. But that testimony was clear, unambiguous. This wasn't a disputed fact in any way, shape, or form. Property owner is the representative is from a much bigger corporation that has many.
But the appellee wasn't claiming that they were liable, HD Supply. That wasn't part of their defense, correct?
I would submit to this court that it was, Your Honor.
How can that be, counsel? Because if you look at the verdict form, the HD Supply was not on the verdict form.
Correct.
The trial judge instructed the jury that the Andros Highmark's defense was that AEI was the negligent one. So it seems to me that the primary reason you believe that this instruction regarding a non-delegable duty should have been given is that the jury may have believed that HD Supply or its installer was negligent rather than the Andros Highmark. But how could that be? The jury was never given an instruction that would have allowed them to say, okay, Andros is not liable because HD Supply is. And the judge also instructed the jury that the defense specifically was that it was AEI's fault because of the lack of an instruction manual on how to properly ventilate these grills, right?
That was one of their affirmative defenses, Your Honor, but their defense, and I'll just read it if I may, Your Honor. Here's what this was the whole theme of their case, and it'll be clear when I read it.
What are you reading from?
I'm reading now from the opening statement, and I'll give you the evidence during the trial, and I'll give you the argument from the closing argument that goes exactly to Your Honor's question. And it says, and I'm reading an impertinent part shorten it. The incident, this is from the appellee's opening statement. The incident report makes it very clear that the information, and this is, I'm not reading the whole thing, but this is about the prior flame incident that put them on notice. They had a problem with the grills that led to the second installation of the grills, is relayed to HD Supply. That intermediary vendor that they, which is the property owner, property manager, count on so that they can talk to AEI, the manufacturer of the grill. What's going on here, AEI? Then, in the closing argument, because I don't get the instruction, I think, they capitalize on the fact that I don't get the instruction, and the appellee's counsel says to the jury, in closing argument, ask yourself, what does a reasonable person do when they believe that they have a piece of equipment that does not function correctly? Is it unreasonable to contact the source for that equipment so that they can coordinate with the manufacturer and tell you what needs to happen next? Is there anything unreasonable about that? The answer is no. The judge clearly instructed them about reasonable care and the duties of a property owner and a property manager. And so, and I can go through the evidence as well that was elicited, but the whole theme of their case was that, and it comports with common sense. We own an apartment complex. We're a big entity. They talk about how the property owner is an LLC that really is just an LLC and there's nobody actively involved, and that they have a management company, which was a defendant. They contact their vendor, HD Supply, who had previously given them, supplied the grills, and there's other testimony that they're turnkey. They provide lots of appliances and things. They saw a problem. They filled out an incident report. They then called that vendor, and that's what they submitted. That's all they had to do because that was reasonable for a property owner to call their vendor.
Wasn't their theme about not having a instruction manual for AEI about the grills and how to operate the grills and install the grills? I thought that was part of their theme too, correct?
That was a part of it, but the central...
was their central theme, correct?
I would really disagree with that, Your Honor.
Okay.
In fairness.
And why is that?
Because what they argued, which is what I summed up in what I just read to this court, is that they acted reasonably. And that tied into the instruction, the standard instruction from the judge about reasonable care. And the thing that the jury must have believed is, and it makes common sense. You own an apartment complex. You got a company that does this for you, that installs these grills. You called them, you let them know, you assume they took care of it. But that's not enough as it relates not to the property manager, but to the property owner who has clearly a legally non-delegable duty. The requested instruction accurately recites the law.
But would HD Supply qualify, in your opinion, as an independent contractor?
Yes, Your Honor.
Because they were the ones that supplied the grills?
Yes, Your Honor. I don't think there was any question that we may have, I can't remember specifically, I'd have to read, but I believe we referred to them as their independent contractor.
Well, let me, I mean, the sole issue we have in this appeal is whether the trial court abused his discretion in denying your request for the special jury instruction regarding the non-delegable duty owed to an invitee, right?
Yes, Your Honor.
All right, and so then when we look at that, then, I mean, you agree with the body of law, if the jury instructions viewed as a whole fairly state the applicable law to the jury, the failure to give a particular instruction will not be error. Do you agree with that?
That is the law, Your Honor.
Oh, okay,
Certainly.
so if I look at, and your instruction is, there's two sentences to your instruction. If I look at the first sentence of your instruction, talks about the duty of the property owner using reasonable care to maintain the property in a reasonably safe condition and to warn somebody like your client of a latent or concealed danger that are known or should be known to the owner and are unknown to the invitee and cannot be discovered through the exercise of due care. I mean, I don't think that's a dispute that that's a correct statement of the law. But then when I look at the instruction given by the trial judge at record page 3847, at least as to this first sentence, I don't know that how it's that different to the extent that it is an abuse of discretion not to give the first sentence of your instruction. That's where I'm having a hard time with your argument. As to the first sentence, I mean, we'll get to the second sentence.
I understand Your Honor's
I mean, that seems to be, you know, we can, in hindsight, we can always try cases better. Hindsight, we can have better oral arguments. But at the time, under the, you know, the Canacaris abuse of discretion, I have a hard time seeing how the instruction at 3847 that lays out the duties. Were they negligent in not, failing to maintain the premises in a reasonably safe condition, failing to correct a dangerous condition they either knew or should have known about, failure to warn your client about a dangerous condition that they should have known, had greater knowledge than your client. I mean, that seems to mirror the first sentence. Yours may be a little more precise. I'll give you that for argument purposes, but I don't know that crosses into the abuse of discretion that the judge reads the standard.
As to the first sentence that cites the law,
Well, your first sentence cites the law, and the jury instruction given seems to say this is the duties that they have.
yes, Your Honor.
All right, so if we
It's-
don't have sentence 2 on yours, then we really wouldn't be having much of a discussion.
Well, there wouldn't have been a special instruction because they covered, yes, to Your
Well, I
Honor's.
mean, but in essence, the second sentence is what your focus is on. The second sentence is,
Absolutely.
the property owner cannot transfer the responsibility for these obligations to an independent contractor and remains responsible for the negligence of his independent contractor. And I don't know that anybody disputes that that's accurate statement of the law, but it seems to be the argument of your opponent that we've never blamed HD Supply about anything. We didn't put them as, I mean, they didn't put them as a Fabre defendant, although I don't think they could have been a Fabre defendant. I know it's not fully brief, but it seemed like it'd be a hard call to say that, under that, especially since that's the statement of the law.
They say here on appeal that they didn't blame HD Supply and actually argue that they never mentioned HD Supply, but very clearly, and I could cite to you the cross-examination testimony by Appellee's counsel of the plaintiff's expert, where they clearly, throughout, their theme is, we hired contractors, we went to the vendor, the intermediary that they refer to. That is HD Supply, and they mention HD Supply by name.
Let's talk about another premise of the law. A decision not to give a requested jury instruction will not be reversed unless the result is a miscarriage of justice or the failure to give the instruction was reasonably calculated to confuse or mislead the jury. Let me ask, was there any jury question raised during deliberations about anything to do with, is the person who installed the defective product, was there anything?
No,
All
Your
right,
Honor.
so there's no evidence necessarily that the jury, there's nothing of record suggesting the jury was necessarily misled by the lack of instruction, is there?
Not through a jury question, but I think not only the questioning and testimony that was elicited during the course of the trial, but the statements made during opening statement and closing argument, in which this trusted intermediary, or whatever the terminology was, and then naming them by name, HD Supply, made it very clear that the argument of the appellee was that we did what a reasonable property owner did. Just what the jury instruction says we're supposed to do. We acted reasonably. And so in the absence of an instruction that tells the jury that a property owner's duties are non-delegable, that's a very cogent argument that the appellee makes. It was crucial. And certainly there was a need for the jury to have a proper legal framework to understand that duty is non-delegable. It's not enough to call somebody who is reasonable. They're a vendor, they're a large vendor, they've worked up for them for years. And there's certainly a reasonable possibility that the failure to give the instruction contributed to the verdict. Not only is there a reasonable possibility, it's likely that the failure to give the instruction deprived the jury of the full knowledge of what the law is as it applied to these circumstances. I think there is no, I'm sorry, Your Honor.
No, go ahead.
Okay. There is no question that it was, as we discussed, an accurate statement of the law. I think there can be no reasonable question that the evidence that was elicited, really by both parties, during the trial supported giving the instruction because we talked repeatedly about what they did and whether or not what they did was enough as a reasonable. And again, I'm talking about the property owner, not the property manager. And that you needed to have this instruction to explain to the court that the property owner has a non-delegable duty, and I would have been able to argue it's not enough. While it may have been reasonable, the step that they took.
Well, let me ask, the first question, the one they answered no on the verdict form that ended their further involvement with the verdict form, talking about the jury, says, did basically the defendants negligently fail to correct or fail to disclose to your client a dangerous condition which was known or should have been known to them, which was not known to plaintiff or discoverable by him by use of reasonable care? They've answered no. So the issue you've raised here for reversible error, how does that tie in with the first question disposing of the case? I mean, if everybody agreed there's a dangerous condition that was not disclosed, and certainly there would seem to be no dispute that they would know better than your client if there was a dangerous condition, then
they say their defense was the property owner is, and managed, both of them collectively. We didn't know because our contractor didn't tell us. It was reasonable that we would contact the responsible contractor, and that's the end of the road for our responsibilities. They asked very specifically, the Appellee's counsel said, so the installer would certainly want to know what is, he's asking the plaintiff's expert, so the installer would certainly want to know what is required before they install a grill into the cabinet, and the expert says, as would the owner of the grill, yes. Question, the owner is going to look at the manual, said, that's the function of the manual. Perhaps the general contractor that built the cabinet will want to know what's necessary for a masonry grill, for a built-in grill. They kept repeatedly harping on the idea that they didn't know about it because they hired responsible people.
Wasn't that consistent with their theme, that the manufacturer didn't provide proper instructions to anyone, the installer, the owner, the grill user, of how to properly ventilate that?
Yes, Your Honor. Yes, Your Honor. And that
goes back to AEI.
Absolutely, Your Honor, and that's why that instruction was so important, because it's okay for the jury, for the parties to argue as to whether their independent contractor could have acted reasonably and whether they should have known from the manual the way it was written. Plenty of evidence that instruction manual was replete. AEI testified in the trial, or lots of evidence. There was plenty of evidence that the manual warned 6 times repeatedly of the need to vent these enclosures. The position that the defendant appellee took in the case was that these warnings were not sufficient because they didn't have pictures. And
I'll let you finish, but you're into your rebuttal time.
Yes, Your Honor.
You've got about 2 minutes, 50 seconds left.
And lastly, that was their position, that it wasn't, and that would have been an issue. Well, was our independent contractor negligent? They couldn't have known either because the manual was not sufficient to warn them. That's okay, those are jury issues, but without the instruction, they didn't have the tools, they didn't have the framework or the knowledge of the law that applied to this case to make that decision. Thank you.
Good morning.
Good morning.
May it please the Court. My name is Geraldine Passaro, and I represent the appellees here in this case. As the Court has already pointed out, the decisions of jury instructions rest in the sound discretion of the trial court and shouldn't be overruled absent prejudicial error. And it's clear that the plaintiff has not proven any prejudicial error here. There was nothing in this case that warranted the instruction of a non-delegable duty. As noted, the defense never blamed HD Supply. It was never requested that HD Supply be a defendant on the verdict form or another party, and a Fabray defendant on the verdict form.
Well, why would they?
Exactly. That's the
Why
whole
would
point.
they? Because they're responsible for what HD Supply did.
No, not for that reason. Only because they were a vendor, and it was described how we got from point A to point B, and that being This was a property owner who took over this property post-construction. How these grills came to be by the former owner, and there was some discussion about the former owner possibly, and the developer possibly being, installer rather, being a Fabry defendant on the verdict form. That was DiPartolo and DDK. The court declined that, and that was fine. With respect to HD Supply, it was just that how did they have notice? And the
But
idea being that there was a fire.
your side owned the property at the time the grill was replaced, right?
At the time the grill was
Okay,
replaced,
so-
exactly.
Right, all right. So the person who's replacing or installing the new grill would be cognizant of the defects of the ventilation with the system, and it seems to be the plaintiff's argument that that installer should have known that it's a problem to install the grill in the context of where the grill is being installed, and therefore, when things go awry, which happened 14 months later to the plaintiff, that's really HD Supply who you guys are responsible for, because you can't delegate that duty to have a safe, a safe condition of your property.
Yeah, but that was not how it was tried at the course of the trial. This is all now briefing post the verdict. It was not tried in that fashion. It was tried that we had knowledge because of this prior incident of the defectiveness of this grill enclosure. Not that the grill itself was defective or the grills that were replaced some 14 months, as you noted, prior to the incident. It was that we had somehow notice of the defective ventilation. It was the defense theory at trial. It was that we did not have notice of the construction manuals as how this enclosure was supposed to be built with proper ventilation or not.
But wasn't there evidence that the HD Supply, when they came in 2016 to put the new grills in, should have been cognizant of that ventilation problem, and therefore that becomes attributed as the independent contractor to you, that's somehow attributed to the owners of the property?
But that was not, again, that was not how the case was tried. That was not.
What is your response to the comments that your opponent made this morning about statements made in the opening and closing on your side that seemed to suggest that they were at least pointing some finger at HD Supply?
Well, again, this was when we do our opening, it's after the plaintiff's opening. The plaintiff, in 3 sections of the plaintiff's opening, pages 24, 24, also on 26, stated and talked about HD Supply, that it was sold through a company called HD Supply. The management company calls HD Supply and says something's wrong with the grills, and HD sends the grills back to AEI. And then even a statement that says it's perhaps HD Supply's fault for putting it into an enclosure that wasn't properly ventilated. When the defense does their opening argument, all at the opening that's discussed is that the incident report about this 2016 flame event made it clear that the information was relayed, that HD is the intermediary, and that so they can talk to the AEI, the manufacturer of the grills. And then in terms of the evidence itself, first witness, they called Brian Sauce. Brian Sauce is the representative of the property owner, and asked about, did you ever hear of a company called HD Supply? So it is the plaintiff that is putting HD Supply out there with respect to this issue of this intermediary. We did not use HD Supply. We weren't relying on HD Supply. We were saying the manufacturer never warned us. We never got anything from the manufacturer about the grill enclosure's requirements to have proper ventilation, not the grills themselves, but the enclosure. So it's important that if there was any question about HD Supply's role in this case, that be brought to the attention of the court prior to the trial. Plaintiff never moved in limine, for instance, to say HD Supply shouldn't come in, or if it comes in, it's going to be deemed an agent of yours, and we're going to have a non-delegable duty argument. These things all could have been fleshed out prior to trial at the time of, prior to the jury being paneled, and we wouldn't be here today, frankly. But it wasn't. Plaintiff did nothing to try to eliminate the error that of which they're complaining about, which is that somehow this issue of HD Supply was confusing the jury. It wasn't confusing. There was no reason to be confused. The non-delegable duty instruction would have been confusing because the appellees came in as one unit, the property owner and the property manager. And if you start talking about non-delegable duty of its agents, it would be confusing to the jury because you could infer that was pertaining to a
How would that be
Highmark.
confusing? They'd say, okay, the owner maybe doesn't know, but they hired these people to install the grills, they are experts in grill installation, they would be cognizant of the ventilation problem that everybody concedes is a defect, and therefore that knowledge is imputed to the owner. How would that confuse anybody?
No, and I'm saying it would be confusing with respect to the relationship between the property owner and Highmark as the property manager, that we were somehow
I
delegated to
thought
the
you all
property manager.
basically lived and died together. I thought
And we
that-
did, and that's the whole point.
Well, yeah, so it wouldn't be confusing to the jury if you both are united saying, you know, if there wasn't an argument made that, you know, if there's liability, it's only the owner or the property manager or one or the other. You guys, if I understood your position was, we live and die together, proverbially, not literally, about this case. So that wouldn't be confusing, I wouldn't think, to the jury if the argument was, okay, yeah, it wasn't either of these two entities that did the installation, but they hired HD Supply to do this, and HD Supply are experts in the field of this area, and therefore they should have known that when they installed these new grills in 2016, that there's a ventilation defect problem, and they should have, you know, and that's knowledge that's imputed up the stream to the owners. They can't, the owners can't, in other words, like the instruction, proposed instruction says, the owners can't say, well, we hired these people, but they didn't tell us anything. It's not our problem that, you know, it's a dangerous condition. They let go forward. I mean, you agree they can't say that.
No, no, we're not suggesting that. It's the question was that the way the proposed instruction was phrased, it would be confusing because the independent contractor in that instruction has not been defined in any fashion.
So if they had, after independent contractor, they had put comma HD Supply, then there would be no confusion, right?
No, well, that would, it still has to comport with the theory of the case. All I'm saying is that that concept of independent contractor could be construed against Highmark, of which we were never taking that position. The trial court asked us, are you trying to deflect against each other? We said no. And we never said we were trying to deflect against HD Supply, which is the important part here. We never took the position anywhere in the proceedings, even during the course of the trial and the testimony, when asking or mentioning very innocuous comments about HD Supply, that somehow HD Supply was the one who should have given us this information. Our position was we did not have the notice.
I mean, I know what your defense was with the Fabre defendant, but I mean, it seems the argument was, okay, look, in 2016, when the new grills are installed, you, HD Supply, come in, you see that when you're installing something, you're on notice, the installation of these new grills, there's still a defect that could be problematic, that makes it dangerous for use. And therefore, you're on notice, you, the owners, the property manager, whatever, you're on notice because the person who's your independent contractor, who you've hired to put these grills in, has the expertise to see that this is a problem. That's the evidence that came in from the plaintiff's side. And so that's their theory is, you know, you guys should have known about this because the guy you had to install understands when you install this, this could be a real problem because of the ventilation problem. And therefore, you know, that when you guys at trial saying, well, if only we had a manual, well, that's fine, a manual, I guess, but I mean, you all weren't going to install it yourselves anyways, so the manual to me is somewhat of a red herring. It's, you hired somebody to do this work, they should have then notified you, oh, by the way, you're going to have a ventilation problem here that could harm somebody. Perhaps you should rethink the configuration of the grill and the you know, et cetera. And you didn't do it, and lo and behold, 14 months later, there's a fire injury. I mean, and I know you argue, well, it's the plaintiff's fault, but that's really nothing to do about anything today of what we're talking about.
Well,
I know that was they never got to that because they went on question one and answered no. So, I mean, I know you talked about that in the brief, and if you want to talk to those two about it, that's fine. It means nothing to me.
no, I think the only point is that there was evidence that did not necessarily conclusively prove that that my clients, DK and Highmark, as a property owner and property manager, had not noticed either constructive and or actual notice.
You can't close your eyes. You can't say, well, we didn't know about it because we didn't get a manual, because you hire somebody else to do it anyway. So manual or not, you know, if I get a manual to my car on how to take care of my engine and I take my car in to get it fixed by somebody, the engine blows up, the fact that I did or didn't have a manual, it's the guy who didn't do the work well on the engine.
Yeah, but there's no notice here from any evidence from any source that either the manual from the manufacturer or from HD Supply that they did impart this notice to my clients, so that there was just
But that's the problem. They don't have to impart it. They don't have to say, do they? I mean, the independent contractor, they don't have to come and run to you and say, oh, by the way, we installed this and we've installed something that's going to be dangerous. Have a nice day. We're letting you know that. I mean, that's the whole point of what his argument and his special instruction is, to say, look, you guys installed something in a scenario that's dangerous. That's all on you. However, you all want to point the fingers amongst the three of you. That's not my problem as the plaintiff. I walked into a dangerous condition that everybody stipulates is a dangerous scenario, and the fact that you didn't get a manual doesn't mean anything. I mean, if you guys did the installation yourself, I think it would make more sense to say, we never got a manual, we did the best we can, and perhaps that would be negligent not to hire somebody, but that's a different story.
Yeah, but we didn't point fingers amongst ourselves. That's the whole point here. We did not ever point finger to HD Supply and say, you should have provided us with this information. You actually had notice of it, and you should have imparted it to us. We never said that.
But because you can't. I mean, if you do that, because it's a non-delegable duty to say, I mean, you might have a third-party action, but as to this case, that's like saying, well, we didn't sue the one who's really at fault, so therefore you can't talk about it at the trial. I mean, they're basically saying to you is, you hired somebody that is an expert in this area, should have told you about it. You didn't get notice from HD Supply, but that the instruction says you don't get to transfer the responsibility to the independent contractor. You're still responsible for them negligently installing this grill in a dangerous scenario that everybody seems to stipulate was a dangerous scenario.
Yes, it was a stipulation that the enclosure as built was dangerous.
Right, but they installed the grill in a dangerous enclosed thing, and they didn't bother to come to you and say, this is going to be a problem, this could be a problem here. And I mean, your position is, well, they didn't tell us, and we're not blaming them, but the other side is saying, but you have a duty to have reasonably safe premises here, and you didn't do it, and you can't simply close your eyes to the fact that your independent contractor didn't let you know about this and perpetrated this dangerous condition to go forward. And I'm not saying with evil intent or anything like that. I'm not saying that. But it was perhaps negligent not to say, well, before we do this, this could be a problem. And then, then you'd be on them. But your position, well, nobody told us, therefore we're not blaming them. But you're responsible for them, and that's all they're saying, I think, in their proposed second sentencing. I mean, the first sentencing instruction is neither here nor there to me.
Yeah, that first sentence portion is not, that's redundant and not necessary.
Yeah,
because
that
the
part,
general
that
instruction
part
covers
is neither here nor there.
And
The second sentence is really the key to this case.
Right, and the second sentence, again, was not necessary here because, again, as the standard is here, it's necessary for the jury to resolve the issues. The issues of non-delegable duty were never raised anywhere in the proceedings. So the jury would be confused, again, by that instruction without having any context. Having the name of HD Supply being the intermediary, who's this turnkey vendor for this property owner, doesn't translate to the idea that there's a non-delegable duty. And again,
Do you agree, counsel, do you agree that under the circumstance of this case, the vendor who also then installed the grills is an independent contractor?
The vendor is, yeah, the vendor would be a contractor of us, again, not an agent in the sense of the word, but an independent contractor. Again, they only supplied the grills themselves, not the enclosure, not the grill, but that was manufactured by AEI.
They were the installer, too. I mean, I know they supplied it. I mean, didn't it come down that they were the installer of the new grills?
That was not clear at trial. They either installed it and or replaced the grills, I think was the testimony, as to what HD did.
Well, okay, I'll ask. They didn't just, HD Supply didn't come to the property owners and managers and say, here's your grills, have a nice day.
Yes, they either installed them or had somebody else install them.
Right.
But I said, from the perspective of the owner, we asked them to come, they're a vendor, come and
Right.
see what the problem is, deal with the manufacturer, and basically
We
take care of
need
the
2 more new grills. We're happy to, HD Supply, we're happy to supply it. and they get put in. They didn't just leave them there and say,
No,
"Good luck."
the testimony,
Somebody did it, either HD Supply or HD Supply had somebody do it.
That
In
was
in
what
any
was-
event, they're all independent. You didn't direct how they were to install them, so they're independent contractors. You contracted with them, and they independently used their abilities and analysis on how to install it.
presumably, yes, that was the...
Somebody did.
Right.
You guys didn't.
Right. Well, it wasn't you guys did it. It was not, again, in a blame sense. It was, these are the vendors, they operate nationwide. You have a problem, you go to them, they take care of the problem, and that's what it's...
I'm not faulting anything about what you all did. We had to get new grills, and you hired these people who are grill people. And they came and brought your grills, and lo and behold, they're in. But the problem in the context of the appeal and the trial, at least according to the plaintiff's side, is, okay, but you installed it in a scenario that it was going to be a dangerous premises, and we used your property that was in a stipulated dangerous condition because of the enclosures. And that whoever put those grills in had the understanding of, by putting them in like that, we are adding or creating, or there is a dangerous condition when we leave, and turn it back over to you guys.
Right, but the evidence, again, just to be clear, was not that HD Supply was involved in the original construction of
No,
it.
I get that, but I mean...
Only when they came and they did the replacement.
I know that, but, you know, I don't think that's an out necessarily to say, okay, we didn't do it back in 2010, we came in 2016, but we see the lay of the land, we bring in these grills, and we should have the expertise to say, if we put our grills in here, this is going to be dangerous to somebody who may use it, who, you know, is not a grill person, it's just an invitee, use the term we're using, the invitee at the premises, and they turn on the grill and it blows up or causes fire and injures them severely. I mean, that...
The test still is, though, whether this resulted in a miscarriage of justice, and the totality of
Well, I
the
mean, I
construction.
agree, that's your best hat to hang your hat on, or whatever.
You know, this failure to give one
colloquially.
singular jury instruction, and we've narrowed it down to the second sentence, or second part of that, would have somehow changed the outcome.
Is the failure to give that second sentence of the proposed jury instruction, is that something that was an abuse of discretion, that the failure to do so resulted in a miscarriage of justice?
Correct.
That's kind of the standard here.
Right, and under that scenario and under that test and how the scrutiny that goes into that test, that was not the case here. The trial
You say
court...
there's no miscarriage of justice, that a correct statement of the law of facts that could perhaps arguably apply was not given.
Well, I don't contend that it comports with the requirement of the theory of the case, that it is an accurate statement of the law. Again, if we're just isolating that second portion of it, because that was not how the case was tried, that's not how the case was presented, those are not the issues at the time of trial in the case, so that this is a situation where we're coming in now, again, after the fact, and yes, trying to create the perfect trial, but that's not how the case was tried, and that was not necessary to the trial. The denial of the charge was proper. The judge considered it with respect to the other parties. Basically says if there was an opening the door, I'd let it in. You never opened the door. So he denied it. The request was made on more than one occasion. It's not supported. It's not necessary to resolve the case. Jury was not misled, and the appellant hasn't met their burden today to show that there was an abuse of discretion, and the final judgment should be affirmed. The new trial denial was proper. Thank you for your time.
Thank you.
With all due respect to my sister at the bar, and who was now my friend at the bar, counsel keeps referring to the fact, this is not the way the case was postured, not the way the case was trialed. The evidence, the documentary evidence.
You're the guy who postured it, right? You're the plaintiff's attorney. You're the one who postured the case, right?
Yes.
And you're saying, here's how I postured it, and it's different than what your opponent today is arguing.
It is.
All right.
Amazingly, we don't agree.
What
But
do you know?
the record
So that's
evidence...
what happens at appeals.
I'm sorry, Your...
So that's what goes on in appeals, if people disagree about stuff, right?
What was the record evidence, very important record evidence, was because these grills were actually replaced twice while this defendant property owner owned the apartment complex. In the same fashion, AEI manufactured, HD Supply replaced them. The shipping, all the shipping invoices, all the records between AEI and the apartment complex is, shows that this company, HD Supply, received them, requisitioned them, and perhaps installed them. That was the evidence in the case.
You
And
didn't
to
think AEI had any responsibility at all, did you?
What's that?
You didn't think AEI had any responsibility at all, whether they gave a manual to the owner way back when or not? Didn't matter, did it?
I think they have responsibility, and I can tell you why. I don't think it's
Well, you only got a
germane to
minute, you'll use your time wisely.
Yes, Your Honor. I want to sum up with my final minute here by reading to you the full amount of what was said in the opening statement, because it absolutely is the way the case was tried and the way especially the defense tried the case. This is from Applee's opening statement. When you read the incident report that the property manager does on behalf of the property owner, what you'll see is that that event was in the process of our maintenance folks cleaning the grill, referring to the first flame incident, not the one where my client was injured subsequently. And when they look back at the grill, there are flames shooting out, actively shooting out through the timer mechanism, burning and melting the grill itself. Not supposed to happen. The incident report makes it very clear that the information is relayed to HD Supply, that intermediary vendor that they count on so that they can talk to AEI, the manufacturer of the grill. What's going on here, AEI? Again, in closing argument, after the instruction is refused, they really kind of double down on that and take advantage of it and says, this is the appellee's comment. Again, ask yourself, what does a reasonable person do when they believe they have a piece of equipment that does not function properly? Is it unreasonable to contact the source for that equipment so they can coordinate with the manufacturer and tell you what needs to happen next? Is there anything unreasonable about that? The answer is no. That was their position in the case. Thank you so much.
Thank you. All right, thank you to both of you. A very well-argued case. Our next